Hi, my name is Ron Miller. I'm a medical malpractice lawyer at Miller & Zoyce. My law firm handles nursing home fall cases throughout the country. Nursing home falls is one of the most common causes of nursing home lawsuits in Maryland, where we primarily practice, and around the country. Elder care facilities consistently ignore the overwhelming evidence of the risk to our elders, and they fail to either implement a fall risk protocol or they ignore the protocols that are in place. In my mind, the key nursing home fall statistic that just jumps right out at you is that 1/3 of nursing home residents who are admitted to a hospital after a fall die within 1 year. I mean, it's incredible. Even if the patient does not die in the hospital, the 1-year mortality rate is 22%. It's not hyperbole to say that the risk of a serious hospital fall or nursing home fall can be graver than the risk of cancer or heart disease in terms of a diagnosis. A nursing home, it's not a fast food restaurant. People live 24 hours a day in nursing homes. These facilities promise to give our elderly adequate care, and they assure them that they'll keep them safe and treat them with respect. And many of these obligations are not just, the law according to Ron Miller. They're set out in federal law on the Omnibus Budget Reconciliation Act of 1987, which is called OBRA, OBRA. And the OBRA regulations are a national standard that are reiterated in Maryland law. The law requires that upon admission, the nursing home must fully assess the patient's condition, functional needs, and functional capacity. This assessment will determine the resident's risk of fall. Assessment guidelines include a complete review of the patient's medical history, recent hospitalizations, medications, visual or hearing deficits, low limb joint function. They look at their gait and their balance, look at their cognition, how well they're doing, are they incontinent, and you look at neurological and cardiovascular conditions, right? If the resident is found to be at heightened risk, what it's incumbent upon them to do is create an individualized strategy designed for that particular patient. How do we protect this person? Nursing homes often fail to develop the right protection protocol for its residents. But a bigger mistake we see as nursing home lawyers is the failure to reevaluate the patient when a new assessment is warranted and reincorporate these developments into a new plan. So they just do it one time and never again. The assessment for a resident when they enter the facility is just of little use years later. So, in sum, the standard of care for a nursing home requires the residents be fully and repeatedly reassessed for the risk of falls, and the appropriate protocols to prevent falls have to be in place. This requires that every nursing home employee is trained and qualified to recognize those residents at risk for falls, and the facility ensures that each resident receives adequate supervision and assistance to prevent falls. Look, obviously injuries from falling in a nursing home can range from minor to major, right? Minor bruises to broken bones to, we see paralysis and death in these cases. It's a tragedy and it can be avoided. Our law firm handles nursing home fall cases. If you have a family member who had a fall in a nursing home and you think medical malpractice may have been a contributing cause, again, my name's Ron Miller. Call me today. I'm at 800-553-8082. I'd be glad to talk to you about your options for pursuing a medical malpractice nursing home negligence case. Thank you.